And Jessica has our next question.
In a 2008 ruling, the U.S. Supreme Court decided that the right to bear arms enumerated in the Second Amendment to the Constitution did not only apply to a militia or members of the military, but to all individuals. The ruling was 5-4, and it has remained a controversial decision. Would you have sided with the majority or the minority in this case, and why?
Said to me?
Yes.
Thank you. Again, you know, I have always held myself to the highest ethical standards, and I will continue to do so every single day as a judge. And again, the rules of judicial conduct preclude me from commenting on the merits of any case, any issue that might come before our court. Why is that? Why do we have that rule? We have that rule because our people need to have confidence that there's no prejudging when they walk into that courtroom, that every single case the judge is going to or the justice is going to have an open mind to look at each and every individual case with the facts and the law. And that's what I've done for 11 years. So I'm going to decline to answer your question on the merits because I think it is so important for our judiciary to be that body that people trust to protect our people. Now, my opponent has been out there signaling how he feels on all sorts of issues that are going to be coming before the courts. Fundamental constitutional issues that are going to have a huge impact on the people in our state. And he asks people, well, I'll set them aside. But that's not the question. The question is, who do you trust? Do you trust someone like that with those kinds of writings and actions to be that fair, impartial, independent justice?
Judge Neubauer, thank you. Judge Hagedorn.
Well, you know, I think it should be concerning, similar to the question we saw about judicial philosophy, where Judge Neubauer doesn't want to answer the question and tell people what she actually believes about issues. We do have a code of judicial conduct that does restrict what we can say about some things, but it certainly does not prevent us from commenting on every sort of question that comes. That's just not true. That's not how it comes out. We can comment on those things. You know, the thing about the Heller decision when it was decided, it was a decision that was based upon the original public meaning of the Constitution, looking at what those words say. So the best thing I can say right now is that they actually used the right approach. We look at what it says. It wasn't about, do we think that gun laws are good or bad? Do we think that we need to enforce some and not others? And that's not what the job of a judge is. And so there's a big debate going on about those issues in our country. But the job of a judge is to be faithful to the law as it's actually written. More to the point, we actually have a right to bear arms. It's in the Wisconsin Constitution, which we are obligated to uphold and enforce. And it's something that I will uphold and enforce and protect, precisely because we, the people, have put it into our Constitution. And that's what every judge ought to do. Far too often we see judges who say on a significant social question, they pick and choose what they like or don't like. They balance things to see what's good policy. But that's not what judges do. Judges are faithful to the law as it's written. That's the kind of judge I've been. That's the kind of judge I'll be on the Wisconsin Supreme Court, unlike what Judge Neubauer has upheld as a model.